Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We've got a question here from Sarah Wood, 8473, not to be confused from Saranda Wood from back in 1963. Is that the song? Yeah, we're not going to get that reference. All right, Sarah Wood, 8473 says, what if there are colleagues who would like to testify and they no longer work for the company? However, the company made them sign a document stating they would never say a negative word about the company after leaving the company. If the employee does not sign the document, then they will not receive their severance pay, which in my case was 2 weeks vacation pay. The employer states that if the employee accepts their severance, then they will be sued if they say anything negative. So now those employees are afraid to testify or act as a witness. Can the company retaliate on the witness under these circumstances? Sarah Wood, you're in luck. So, listen, there's a lot you can do with an NDA. Non-disparagement provisions, confidentiality provisions, there's a lot. There's a lot you can do, and there's a lot that's legal in a lot of jurisdictions. Here's the thing. You're never going to be able to contract around the big dog, the court system. So you can make a contract for damn near anything that's not illegal. But you know what's illegal? Generally speaking, in a lot of circumstances, ignoring a subpoena from the federal court system of the United States is going to be pretty goddamn illegal. And so, generally speaking, if you can subpoena a witness to come in and testify, that is going to blow this non-disclosure agreement, this NDA, this non-disparagement provision, this confidentiality provision, this severance package out of the water. Nobody cares. Oh, did you contract to have this protection? That's cool. That's great. Did you think that was going to beat the federal court system? Because if you did, you're not a very good lawyer, right? So, Sarah, great news. Just subpoena your witnesses. Have them come in. If you really want to protect them, you can pretend like you forced them to come in. But you don't really have to, because at the end of the day, they're complying with subpoenas. And they can't really be punished for that. In fact, if something negative happens to them for complying with a subpoena in a workplace discrimination or workplace sexual harassment case, that's going to give them a fresh claim, a retaliation claim, in addition to other things, which, like, the court system might think that if you're going after someone for complying with a subpoena, well, you might have some contempt for the court system. In fact, you might need to be punished. Yeah, court might play whack-a-mole with defense counsel, right? Like, not unheard of, right? So, Sarah, great news. Yes, this is scary. This is sticky. This is an obstacle of sorts. But it's an obstacle that can be dealt with. It is a sticky situation that can be wiped clean. It is fixable. Eminently so. And I would urge you to be in touch with those witnesses, to protect those witnesses, and plan ahead for how you're going to depose those witnesses. And this is something your attorney should be on top of early and often in the case. This is the conversation you should be having. Who was there? Who saw what? Who can support your version of events? Who's going to be a great witness for your narrative, right? Like, these conversations happen, or they should. And the next part of that is, okay, these people, how do we get these people in? Will they come in? Can we get them to do an affidavit now? Can we lock them in? Oh, no, they can't do an affidavit. They're subject to an NDA. Okay. Well, how quick can we get discovery? How quick can we get discovery to depose these people? We'll subpoena them. We'll have them come in, right? Just plan ahead. It's manageable. It can be done. You're in a good place. Or if you're the witness, Sarah Wood, and you want to testify, and they come to you and like, hey, we need you to testify. You're going to have to risk it all. Like hell I do. I'll tell you the truth. I'm here to help. But I'm going to need that subpoena, that sweet, sweet subpoena, because I'm not going to risk myself. I'd love to do the right thing. I'd love to tell the truth. In fact, you know what I'm really good at? Really good at telling the truth. I'm incredible at telling what happened. But I'm not going to risk myself, and I got a bank account, and I got a house, and I got me some kids. And I'm not looking to lose that bank account. I'm not looking to lose this house. I'm not looking to lose that ability to feed those children. So yeah, go ahead and get the subpoena, dog. Let's make it happen, okay? Like, don't be inconsiderate. Don't ask me to sign an affidavit and put myself at risk. Just get the subpoena. Protect me. And I'll help you. Because I like the truth. I like doing good things. I want help. But I want to help at no risk to myself. Makes sense. Very rational. Very, very rational perspective for a witness who is subject to an NDA, a non-disparagement, a confidentiality clause, whatever it is, right? Some severance package with this language in it. It's just, hey, help me help you. I want to help you. That employer, they're bad people. They do bad things. They're bad people who do bad things. I would like to mess them up. I would also like to keep my bank account. So, fix it. Fix it, attorney. Plaintiff's attorney, all you got to do is the work. Not my problem. I'm here to help. Here to tell the truth. Just fix it. It can be done. Sarah, there's just a lot, right? One last thing to note. If you are opposing discrimination, and that would include testifying in a discrimination case or a sexual harassment case, right? If you're opposing workplace discrimination, workplace sexual harassment, that is a protected activity. You are engaging in a protected activity. So if someone does something negative to you, like say the employer, past employer, current employer, whoever it might be, and they're doing it to you because you're opposing discrimination, that is a potential claim. In most of the country, that is a claim under federal law, state law, and potentially local law. But I'll tell you right now, it's definitely a claim in all 50 states under federal law. So if someone's doing something bad to you, it's called a negative workplace consequence. If you're experiencing a negative workplace consequence because you are testifying, you are opposing workplace discrimination, workplace sexual harassment, you have now a private right of action for your own claim. That is a retaliation claim. And retaliation claims, as we know, can be valuable. Those claims can be worth money. Now, listen, do you want to claim? Do you want to bring a lawsuit? I don't know. I'm just saying, like, there's additional protections here. There's additional things we can do for you. And again, plaintiff's counsel, you want me to come testify. If I experience retaliation as a result of my testimony, what are you going to do for me? You got to bring my retaliation case. Like some reassurance, like some assurances before I testify. If I experience retaliation, you going to take this case? Not unheard of. Not unheard of for a plaintiff's firm to say, hey, you come and testify. It's illegal for them to retaliate against you. But if they do, we'll run that case for you. Because we want to win this case right now for our client today. And we need you to come in and testify to get that done. So, listen, if they retaliate, we'll open a fresh case for you. Let's do it. We got your back. We got your back, right? And you got to be careful. You got to be careful on how you handle that because it can look like you're making deals with witnesses, and that's not what you want. So you got to be careful. But listen, there's certainly ways you can have conversations. Like, listen, if they retaliate, we can have a conversation. We love retaliation claims. We want to help you. We want to protect witnesses. Like, there's a lot that can be said without it, getting into the realm of the inappropriate or the questionable or the witness tampering, right? And not unheard of for a witness to ask for those assurances. So Sarah Wood, if you're nervous, ask. It may be given. Anyways, if this video was helpful, like, subscribe, comment down below, share our channel so it may grow. Take care, everybody.